Here at Plumides Romano, every case that we handle, no matter how small or how large, we start off with a position of litigating it, going to trial. That's how we want to prepare. That allows you to make the proper decisions in whether or not you actually litigate, or what's traditionally known as going to trial. You'll see on TV, people will sit in a courtroom, there'll be a jury and a judge. Now, not all cases in the state of North Carolina have a jury. You'll see in family law, most of them will have judge trials only. But again, what we've done, and again, dating back to when my father and my uncle began practicing and historically started the firm, they did it that way. They prepared for court, regardless of what the aspect or what direction they were going in the case, so that they knew at all times they were prepared to try a case. And when you're prepared to try a case, you can help your client make the decision on what's best for them. If you go to a courtroom unprepared, you can't properly tell your client what's best for them. So we pride ourselves on that. And the four of us here, Mr. Johnson, Mr. Romano, Mr. Gutierrez, and myself, often talk about our cases, and we look at it from that perspective. Preparation being the number one thing. And that's what you'll see the difference that we have when it comes to litigating a case, is we're wholly prepared and we encourage our clients to meet with us as often as they can so that they too can be prepared. Now, the big difference that you see in criminal cases is that in felony criminal cases, you will have a jury. In misdemeanor criminal cases, you get two bites at the apple. One is a judge hearing, and then if you were to lose that hearing, you can then appeal and request in Superior Court a jury trial. That's a big decision. Judges in Superior Court sometimes are a little bit more harsher on punishment than judges in misdemeanor court. So you've got to make a lot of serious decisions. You've got to, for instance, in a DWI case, determine whether or not you think your client will get a limited privilege if they appeal their case. There are some instances where judges, both in district court and superior court, may choose not to give a first offense DWI individual a limited privilege. And those are things you discuss with your client. But it all goes back to being prepared. And if you're prepared from day one, you can help your client make that decision. Civil, the big difference in civil is you have a much deeper or more involved discovery process, meaning when you sue someone in a domestic case, you have the ability to collect information from them, either through requests, discovery requests where you ask for documentation, or questions called interrogatories where you ask them questions. That information, you have a time period to get that information. In criminal matters, separate and apart from your own investigation, your own preparation, the state or the government in a federal case is required to provide you with discovery. So it's a different process. And sometimes, especially in federal, the cases move much faster because of that aspect of it. In domestic or civil matters, things can go a little slower. However, again, our goal is preparation. So through each aspect of a civil case, we set timelines for ourselves to make sure we have the proper documentation. And again, we encourage our client to work with us as much as possible. Again, the goal being prepared so you can make a proper decision at whatever stage you are in the litigation.